Good morning or good afternoon. Thank you everybody for joining early. That's great. Let's more people waiting. Let me admit them. All right, let's begin. Let me first of all share my screen with you. Well, hello everyone. I don't know whether it's morning or afternoon where you are. It's early lunchtime where I am. As you know, I'm in Dubai. I'll be here all week, at least. Well, we're now reached lesson 7 of the course. Let me increase the size of the presentation. And what we're going to look at today, it includes legal idioms and some more legal Latin, and also a technique which I want to show you which might assist your legal writing. And that is how to write using as few legal prepositions as possible. I know legal prepositions are very difficult. The only way to learn them is through constant practice. I don't want you to write so that you make mistakes, so I've taken a small excerpt from our legal writing course, looking at some 5 techniques for writing without using so many or too many prepositions. This basically should assist you to write grammatically correctly so that you can reach the full stop at the end of the sentence without making a mistake. As you know, very unfair though it is, many other people will form an opinion about your legal professionalism from the standard of your legal writing, which is why the legal writing course, which I'm taking this excerpt from, is so popular. It's the basic building block of your entire legal career if you're going to practice international law. We'll do a bit more legal Latin as well. Again, I won't go through all the words which I put into the presentation, but I'll pick out some of the important ones, leaving you to download the presentation later and go through them on your own. However, let's begin from something from the legal English course, which is to do with legal idioms. Now, of course, this is incredibly difficult. English is an idiomatic language. So it's difficult to learn English to understand our strange conversational idioms. It's not cricket. It was like talking to a brick wall. I heard it from the horse's mouth. What on earth can that mean? Well, legal idioms are even worse, because it's idiomatic language used in the law. And the problem about the idioms is the individual words which make up the idioms have a completely different meaning from the idioms when the words are used individually. In many cases, you cannot even take a guess at their meaning. The only way to learn them, I'm afraid, is by using them. Now, many of these idioms are also frequently used in general English, because even in general English, people still talk about crime, about justice, about criminal offences and courts. Ordinary members of the public speak about these things, not just lawyers. So you'll find some of these idioms in ordinary conversation as well as being used by lawyers. Now, there's hundreds of these. There are hundreds of these idioms. I can't go through all of them, but I'll go through some of them with a short explanation about what they mean. At arm's length. Well, this is often used to describe negotiations and contracts. It means at a distance, avoiding intimacy or familiarity. And what it really means in legal terms is that we didn't put any unfair pressure on the other party, even the unfair pressure of them being a friend. So, for example, I might say, we purchased the property at arm's length and we are not involved in any management decisions. In other words, we're not involved. Or something from a trial, a criminal trial, beyond a reasonable doubt. This is a legal phrase that means something is almost certain, and that the suggestion being put forward in court has been proven sufficiently so that there's no reasonable doubt in the mind of a reasonable person that the defendant is guilty of the crime they are accused of. You might hear someone say, the judge sent the man to jail because the jury believed beyond a reasonable doubt that the man had committed a crime. By the book. The book we're referring to is the rule book. It means following all the rules when you do something. For example, our lawyer is very good and he does everything by the book, meaning he's very particular and precise in every document that he prepares and every court action he's involved in. Everything is correct. To come clean. Well, this has nothing to do with getting washed or bathing. To come clean with someone about something, it means to admit your part in something, to be completely honest with someone about something that you've done or been involved in. For example, the man decided to come clean with the police when he confessed everything about the crime. Or to go on record. Well, as you might guess, it means to make an official statement as part of the official record rather than making some informal sort of statement. For example, the mayor of the city will go on record to oppose the new convention centre. And now, again, from an argument, not to have a leg to stand on. What on earth does that mean? Well, it means to not have the facts or evidence to support or win an argument or a legal charge that is made against you. To not be able to defend yourself or argue with the other person. It's usually used in the negative. He doesn't have a leg to stand on, he'll have to accept our offer. He cannot defend himself against us. For example, the apartment manager tried to evict the young family, but he did not have a leg to stand on and he lost the case in court. To jump bail. Well, to be bailed means to be released by the police, awaiting the full trial. To jump bail means to run away. He's jumped bail. The criminal jumped bail and went to live in another city. And then a very idiomatic expression from ordinary English, to lay down the law. It means to state firmly what the rules are, the law are for something. Now, this could be in a family dispute, could be in a dispute with a relative. The father laid down the law to the young boy about where he was allowed to play. Or we decided to lay down the law regarding the vacation schedule for our employees, meaning we're informing them very severely, very strongly, what the rules are. Now, to put something down in black and white. Well, of course, this means to write it down. To write something down, to make or draw up a contract, to set out the rules in writing. I want you to put it down in black and white so I can read it and understand it. And then to run afoul of the law. A-F-O-U-L, afoul, means bad. Means to get into trouble with the law. To run afoul of the law means to get into trouble with the law, usually because you've done something criminal. The young man ran afoul of the law and was taken into police custody. To serve notice on. To serve notice on someone means to deliver a legal announcement or a legal document to someone. For example, the company served notice on the workers that they would close the factory next year. Or to show cause. Courts often ask people to do this. Show cause why we should not give the order against you. Or show cause why we should give you an order in your favor. It means to give a reason or an explanation for something. For example, the lawyer was asked to show cause about why the man was guilty of the crime. Then the spirit of the law. The spirit of the law means something as it is meant to be, and not as it is stated exactly. What the intention of the law was, rather than the meaning from the way it's written down. What the people who wrote the law wanted to achieve. For example, the judge tried to follow the spirit of the law, and not only as it was written. To stand one's ground. This means to stand up for your rights. For example, I stood my ground and refused to do anything that was not totally honest. And you might tell somebody in an argument, don't give in, stand your ground. Stay of execution. No, it doesn't actually mean to be executed. But execution also means the carrying out of a court order. So a stay of execution means to temporarily stop a court order. Could be a court order to seize goods, to take money from a bank account. It's a court order to temporarily stop another court order or judgment. It can be used for any type of court order. For example, there was a stay of execution on the order to demolish the old house. And to stretch the truth, an idiomatic expression again from ordinary conversation, means to misrepresent the truth, usually in a small way. For example, my office is on the 11th floor. This building has 15 floors. I could say, stretching the truth in a small way, I'm on the top floor of the skyscraper where our offices are located. That's not quite truth, is it? I'm in an office block, but I'm not on the top floor. And I'm not sure I'd call it a skyscraper, as it's 15 floors. That might be a slight exaggeration. I'm stretching the truth. You might hear, the witness was stretching the truth when she told the judge to excuse her for the crime because she was desperate. Maybe she wasn't desperate. Maybe she was just in a difficult situation. Now, another idiomatic phrase from ordinary conversation, to take the law into one's own hands. This is to try to administer the law on your own. Now, usually this is not legally permissible, and it also usually implies that some sort of violence has been used. For example, the transit supervisor was taking the law into his own hands when he tried to arrest the man. Presumably the man was traveling on the bus without paying for the ticket. Now, to take precedence over something, again, something you use in the law. To take precedence means something is preferred in favor of something else. To be more important than someone or something else. To have the right, for example, to receive payment before someone or something else. The preferred creditors will take precedence in the distribution of company dividends. The laws about the safety of children take precedence over many other laws. And then again, an idiomatic phrase from ordinary conversation and also used in the law, with no strings attached. Basically means with no obligations attached. I might offer you something without requiring anything in return. It's an offer with no strings attached. For example, the man was forced to agree to the terms of the agreement with no strings attached. And then we come to another idiomatic phrase from ordinary conversation as well as the law, to turn a blind eye to something. You may know of the story of Nelson, who had one eye, was asked about the foreign ships he saw in the distance. Why wouldn't he attack them? He put the telescope to his eye patch and said, I see no ships. He wasn't ready to attack. So rather than seeing them and failing to do his duty, he put the telescope to his blind eye. It means to turn a blind eye basically means to be aware of the facts, but not to act on it. To pretend not to see someone who's doing something wrong. To pretend not to see something that is troublesome. For example, the police often turned a blind eye to people who cross the street on a red light. So scratch the surface of that topic. These idiomatic legal phrases can be used in legal arguments and also sometimes in ordinary conversation. There are thousands of them. We cover a lot more in our legal English course, but that's as much as I've got time for today. Now, I want to deal with something else, something relating to your legal writing. As I explained earlier, legal prepositions are very difficult to deal with. I don't want you to make mistakes in your legal writing. So one way to cut down on this is to find a style of writing whereby you don't use so many prepositions. That way, at least, you won't make mistakes. Well, there are 5 techniques for this. You know that prepositions are words that indicate relations between nouns, pronouns, and verbs. Mostly prepositions are small words like in, on, of, to, with. Sometimes they're more substantial. Beneath, between. Sometimes they're prepositional phrases. Across from. They're often integral to a sentence. But if you put too many of these prepositions into the sentence, you will clutter up the sentence. You will obstruct the readers from getting to the main information and phrases in the sentence. They make your writing difficult to read. They make it, we would say, cumbersome. They make it awkward, as we'll see in this presentation. We want to write sentences that convey our meaning and which also keep the readers engaged. I don't want to write something that's factually correct, but have the reader get so bored with what I'm writing that they reach the bottom of the page and then ask themselves, what have I just read? Because I can't remember any of it. We want sentences that flow. Now, this is very hard in legal writing because you're stuck with the facts and the law. So this little topic I'm looking at now talks about two things, using excessive prepositions and also compound prepositions, which are prepositions on steroids, if you like, where you use 3 or 4 words rather than just one. Now, first of all, let's look at excessive prepositions. A sentence with too many prepositions becomes awkward, difficult to read through, and it's very hard to read it quickly because you have to understand what each preposition means. For example, look at this sentence with 5 prepositional phrases in just 20 words. A knowledge of correct trial procedures is the duty of all the members of the bar of this state. Wow, that's very awkward, isn't it? With a little thought, we could just remove them, like this, at the bottom of the screen. All state bar members must know correct trial procedure. All you had to do was sit, look at the sentence for a while, and work out your message, and then rewrite it without any prepositions. And it's a much more vigorous sentence, isn't it? Much easier to understandable. All state bar members must know correct trial procedures. Or look at this. There is no current estimate of the number of boxes of records in possession of the schools. You think I'm making this up? I'm not. This is actually taken from a real sentence written by a real lawyer, a native speaker of English as well. 5 prepositions in just that tiny little sentence. Sometimes we don't want to take out every preposition. Otherwise, we're just left with sentences filled with nouns. But with a little thought, we can change this sentence and just leave 1 preposition. We say, we have not estimated how many boxes of records the schools have. And it means exactly the same as that awkward little sentence I've just read out. I've cut it down to 1 preposition. That's 1 chance in 5 of making a mistake, not 5 chances. So when you edit your writing, look for short bursts of prepositions coming at you in waves. Maybe you just have too many prepositions then. Look for prepositions specifically. You will engage your reader much better if you cut out excessive prepositions. Now, how can we cut them down? Well, the first is, as I think I told you in the very first lesson, use the active voice. Use the subject-verb-object sequence. Shifting from the passive voice to the active voice usually cuts out at least 1 or 2 prepositions. For example, here's the passive voice. The watch was obviously designed by a master craftsman. Yeah? So I could put it in the active voice. Who did it? The master craftsman. So we say, a master craftsman had obviously designed the watch. Takes that by, that preposition, takes out the sentence altogether. Next, rather than use a prepositional phrase, use an adverb instead. For example, here's a prepositional phrase, with vehemence. With is the preposition. With what? With vehemence. For example, the witness responded to the allegations with vehemence. So we've got two prepositions. I can get rid of one of them by turning with vehemence into the adverb, vehemently. The witness responded vehemently to the allegations. It strengthens the idea and it deletes that very weak preposition with vehemence. What is that? The witness responded vehemently to the allegations. Vehemently means extremely strongly. Next. Now, this will be easier for those of you from Russian or Slavic speaking languages, or those of you who use a case-based language. Most of us don't. English is not a case-based language. The genitive. The genitive case, from those of you who know Latin, means the type of thing, a bottle of milk. So it was a bottle. What type of bottle was it? It was a bottle of milk. That's the type. That's the genus, the type. So an easy way to help reduce the number of prepositions is to search to see if the sentence contains the genitive case, or what you might call the possessive. If the sentence could use the genitive case but doesn't, then rewrite it. Now I have to explain this a little more fully. For example, here's a sentence. She was disturbed by the violent images in the movie. So we've got two prepositions, by and in. She was disturbed by the violent images in the movie. Now, let's reverse the information. What type of images were they? They were violent ones. What kind of images were they? Violent ones. That's the genus, the type of images. So, let's reverse the information, turn it slightly into the genitive. She was disturbed by the movie's violent images. Now I've got rid of wrong preposition by turning it into the genitive. Now, let's go back to what we just looked at. Let's combine it now with turning it from the passive into the active. Who was it that did something to her? Well, it was those violent images in the film, wasn't it? So, the movie's violent images disturbed her. Now we got rid of both prepositions, turned it into the active voice, and we've used the genitive. And we've got rid of both prepositions as a result. Now you won't have any chance to make a mistake with the preposition. Right? Now, use a genitive in place of a prepositional phrase. By a prepositional phrase, this is a place within a place. Right? For example, the Museum of Modern Art in New York City. Of and in, two prepositions. Well, what place am I talking about? I'm talking about New York City's Modern Art Museum. Now, admittedly, that's a 6-word, multi-word noun. It shouldn't be used very often because multi-word nouns of 4 and 5 and 6 nouns, they clutter up your writing. But occasionally, it might be better to use it rather than using the prepositions. The Museum of Modern Art in New York City sounds a bit awkward. Let's be very direct. New York City's Modern Art Museum. Sounds better. And now, eliminate nominalizations. Remember nominalizations, they're the nouns which we use instead of the verbs. They're the nouns which give the name of the process rather than the verb, which does the work. In America, they're called buried verbs or smothered verbs. In most of the other common law countries, English-speaking countries, they're known as nominalizations. When you turn them back into verbs, they eliminate the need for at least one preposition. For example, here's a sentence. Their attempt to provide a justification of the expense was unsuccessful. Well, justification is the verb justify, which has been turned into the noun for the process. Let's turn it back into a verb. Their attempt to justify the expense was unsuccessful. I've got rid of one preposition. I've got rid of the preposition of. Yeah? And finally, prepositional phrases themselves. Well, this is prepositions on steroids. These prepositional phrases don't really add anything to your writing. They just get in the way of the information. They're great when you're making a public speech, when you want to sound pompous, when you want to sound serious. But in writing, you don't want to appear to be pompous or take up too many words. So while they're fine for making public speeches, they're not good for writing. For example, the best outcome for this scenario would be an incremental withdrawal. What does for this scenario mean? What function do those three words fulfill in the sentence? Let's just get rid of them. The best outcome would be an incremental withdrawal. I've got rid of the entire prepositional phrase. I've got rid of the preposition plus a couple of extra words. The best outcome would be an incremental withdrawal. Well, shorter, clearer, more precise, and easier to understand. By removing as many prepositions and prepositional phrases as possible, you can improve your writing. You make it shorter, clearer, and it fulfills the overriding intention of legal writing, which is to make it easier for the reader to understand. Because, after all, why are you writing to the reader? You're writing to give them information or ask them questions which they can understand. Writing so that they can't understand defeats the entire object of writing to them. Cut down on your prepositions, you will improve your writing. Okay, well now the last thing I want to look at today is some more legal vocabulary. Now again, I know from studies I've read by psychologists and psychiatrists, they say you can't take in more than 20 new words in a language in one day. And legal English is a language. It's different from ordinary English. So I'm not going to go through every single phrase in this legal vocabulary, which I've got in front of me now. I'm going to go through some of the main ones, and then we're going to make this presentation available to you so you can download it and read through it slowly at your own pace to take in the vocabulary and phrases and their meaning. Let's pick on some important ones now. Well, to accuse. Well, that's basically to say somebody did something without actually having any evidence. To state that somebody's done something bad, like a crime, without having any evidence. For example, the bookkeeper was accused of stealing from the company, or you're accused of theft, or this is a serious accusation. To acquit. Well, this obviously comes from Latin and French. It means to be found not guilty. To dismiss criminal charges after trials taken place. Now, from court cases, Latin, but it's very important Latin, an action in rem. An action in rem means a court case brought before the court in respect of a particular item, a thing. It might be a painting, it could be a ship, it could be a house, it could be a piece of land, but not money. Thing in particular. So an action in rem, you'd use this to claim a specific item which you said somebody else had possession of and you wanted. For example, the widow brought an action in rem against the bank for return of her dead husband's house. Or the lawyer in court might stand up and say, this claim is an action in rem in respect of ownership of goods in my client's warehouse. Right. An action in personam is the opposite. This is an action brought in respect of money. I want damages. I want financial compensation. So an action in personam is a case brought in respect of general monetary claim. For example, damages for financial loss, rather than to recover a specific item. This is the exact opposite of an action in rem. For example, the plaintiff began an action in personam to recover general damages for unfair dismissal from his employment. Ad hoc. It means for one purpose. You can have an ad hoc committee, an ad hoc meeting. It means for one purpose. There's only one thing we're going to talk about. It's created to do one thing. For example, Following the shipping collision, an ad hoc committee was formed to investigate the accident. Or this is an ad hoc decision taken purely in respect of these circumstances, does not affect any other cases. Ad litem means at law. It means for the purposes of the case. For example, maybe a child has to bring a court case. Well, a child can't bring a court case, so they have to get an adult to do it for them. That would be the guardian ad litem, the guardian for the purposes of the court case. Additor. This is important in the common law jurisdictions. It's where a trial judge adds damages additional to the amount awarded by the court for the general claim or awarded by the jury. Adjourn, well, that means to postpone. Adjournment means a postponement. Cases often get adjourned because witnesses can't attend, or adjourned because they've reached the end of the court day. Bar, B-A-R. Well, obviously, this is the legal profession of people who speak in court. If you go to Sandwich Magistrates Court down in the south coast of England, it's a very, very old court. They've still got the metal bar from 1,000 years ago, where the prisoners were called to stand in front of the judge. And their lawyer would go and stand beside them at the bar. That's what it means, to be called to the bar, to go up and stand by your client, to speak on their behalf. And a barrister. The reason I've included this is just so you understand the pronunciation. It's barrister, barrister, not barista, which means somebody who makes coffee. They get very upset if you mix them up. I mean, the lawyers do. The lawyers get very upset if you call them a barista. They're barristers. It means a lawyer who's permitted to speak in the senior courts. Breach means to break. You break a contract by breaching it. A covenant. Now, covenant has many meanings. Covenant can mean an agreement. Covenant can also mean a clause in a contract. Perhaps it's best put as an agreement or promise between the parties in the form of a contract or the part of a contract. Covenant is also a synonym for a clause in a contract. For example, this business purchase agreement contains a covenant not to compete by the vendor. Criminal law, well, that's all the law relating to crime and punishment, as opposed to all the civil law relating to banking and finance and families, corporate law. Crown Court has a different meaning in certain countries. It's a senior court in the criminal system. Crimes of robbery and murder can only be dealt with at the Crown Court in the UK. Now, the corporate veil. This is important in corporate law. It's a general provision dating back 600 or 700 years that shareholders in a company can keep their names and addresses secret. It's like wearing a veil, a cloth in front of your face. You don't know who it is. Corporate veil refers to the fact that companies can keep the names and addresses of the shareholders secret unless forced to reveal them by the court or by the government authorities. Usually if some sort of criminal action has taken place in the company. A counteroffer, very important for contracts. Somebody makes an offer to you. You can accept it. Those are two of the essential requirements of a contract. If you try to negotiate, you don't accept, you make a counteroffer. I offer to sell you my car for $10,000. You say, I'll pay you $9,000. You didn't accept my offer, you made a counteroffer. The danger is, in the common law, counteroffer kills off the original offer. If I was then to say to you, no, I won't accept $9,000, you could say, all right, then I'll pay you $10,000. But because you've already killed off my original offer, I could just say, oh, well, I've changed my mind. I don't want to sell it to you now. Now, let's have a little exercise. I know it's boring to listen to me lecture. So, here's some questions about the vocabulary. Here's a question with 4 potential answers. What is the legal meaning of the phrase action in rem? Is it A, B, C, or D? Let's see what we've got. I'd like as many people as possible to join in answering these questions because it makes it more interesting for me. We got 2 answers so far. Is it a case brought to recover monetary damages? A case brought to recover a specific item of property? Is it the profits lost from an uncompleted contract? Or is it any uncompleted court case? That's how we got here. An action in rem. Let's see. It's, oh, everybody's got it. Yeah. And that is quite right, everybody. It's B. Well done, Sarah, Shukat, Leo, Teo, Vincent. It's an action brought to recover a specific item of property, a thing, rem, thing. All right, next. What's the legal meaning of the legal phrase ad hoc? Is it a loan where the security is left with the lender? Does it mean for one purpose only? Does it mean something that's completely bad? Or does it mean until the end of time? Let's see who's got the answers right. B. Yes, very good. Everybody's got the right answer. Oh, well, too easy then. For one purpose only, an ad hoc committee. Good. Let's just have a look at that last one. B. Very good, Catherine. Yeah, very good. Right, here's another. What's the legal meaning of the phrase ad litem? Ad litem. Okay. No advance on 8, I don't think. Let's see what you say. Yes, it's C. Well done, everybody. Well done, Mahmoud, Anna, Barbara, Yelenia. Good, it's C. It's at law. Guardian ad litem is a guardian at law. And last one for today. What's the legal meaning of the phrase corporate veil? Does it mean pretending the company is more valuable than it is in reality? Pretending your goods were produced by another company? Where the identity of the other party buying the company shares is secret? Or is it the shareholder's right to anonymity? Anonymity. Let's see, let's have a few more answers first. It's D. It's the shareholder's right to anonymity. Well done, everyone. Shareholder's right to anonymity. All right, well, thank you very much for joining me today, everyone. That's all for today. As usual, we'll edit this recording and put it up on the YouTube account. I'm delighted to see over 1,000 people have watched the lesson number 1. And more people each day are watching these recordings. It's great. Please tell your friends about them. The whole purpose of this really is to test our broadcasting systems. Now, I have to tell you that as we're coming out of the lockdown here in Dubai, Thursday's lesson will be our last lesson. We will be announcing a number of other courses starting on Thursday, which you can join, but Thursday will be the last lesson of this free general legal English course. So it will be great to see all of you. So I hope you have a nice week until Thursday this week. I look forward to seeing you then, and thanks for joining us today. Goodbye, everyone. Bye-bye for today. Bye-bye. Let's have a look at your messages. Thank you. Oh, thank you, Sarah. Thank you very much, Tayo. Thank you very much, Barbara. We'll stay safe. Thank you, Elenia. Thank you, Aliyah. Thank you very much. I'll sign off now and hope to see everybody on Thursday. Thank you.